All right. And where had you seen this screenshot? I found it on the original image of the device. Has it been modified in any way? That's exactly how it looks on the image as well. You also testified that FTI report that was, it looks like prepared July 31st, 2025. Yes. All right. And on the third page of that report, there are several dates that are listed, correct? Yes. Those dates represent what exactly? So this database keeps track of the Wi-Fi data use. So it's an artifact related to the phone activity, not to the application specifically. All right. So what would trigger, I guess, the creation of these dates? WhatsApp, the court. So we're looking at page 3 of Exhibit M. I just want to make sure that I'm on the same, Mr. McLemith. I didn't get a letter for this. Is this the FTI report M? 6 pages long? The court. Yes, I have that as plaintiff's Exhibit M by Mr. McLemith. Sorry about that. So Exhibit M, page 3. There are several dates towards the bottom of those dates there. Thank you. Those dates were triggers the, or what generates those dates. So the phone has a database that keeps tracks of activity over the Wi-Fi card. And those dates are related specifically to WhatsApp activity. All right. But when you say WhatsApp activity, I don't know if that's a message being sent or a message being received, or just maybe pressing the app on the phone and going into it. Could you tell me what type of activity could generate that date? It doesn't specify. So it doesn't necessarily mean that there is a message sent or received for this data to be generated. Is that correct? Correct. So you don't know, or you can't testify as to where or whether there are a message in WhatsApp sent or received on any of those dates or in that report. Is that correct? I would need to take a look at the second image, because the second image had 6 WhatsApp messages, if I recall correctly, and I would need to check if the dates match with any of those date ranges. But you have not done the analysis? No. How long would it take for you to do the analysis? We could do it now. It's only a few messages, and we can compare it to the dates which would match with this. Okay. Do you want me to do that? Yes. The court. So while that's happening, I understand the parties have not had an opportunity to present argument yet. But I'm understanding that there are 2 different dates on which Ms. Cooper's phone was. Either one date was extracted, and then on another date, there was a hard drive sent to FTI. Do I understand that correctly, Mr. McLemith? Or hand delivered, Mr. Sullivan? It was physically delivered to us in Mrs. Cooper's deposition room. The court. During the deposition, Mr. Sullivan. And then we gave that to FTI, the court. So both of those were analyzed. One, the extraction, Mr. Sullivan. We just got those here. I'm going to clear up this thing about the later one, because he's got the database right here. He can match up those dates. The court. Okay. That just gives me enough background to understand this testimony. The witness. So should I display my laptop now, or you can see the WhatsApp messages on the new backup, Mr. McLemith? Yes. And this is going to be a bit small. I don't think I can make it bigger, but in the backup we received in July, there were 6 WhatsApp messages, and they were sent or received on July the 17th, 2025, and July the 15th of 2025. All right. So that doesn't help us to determine whether there were actually messages sent or received in any of the dates on page 3 of Exhibit M. That is correct. Just to make sure we're all on the same page, these WhatsApp messages are from the image we got in July. And the analysis of the database was done on the phone that we imaged in April. So the image in April would not have covered the period of those WhatsApp messages that we received in July. All right. Now, they were actually messages, in the second hard drive that was turned over, the second analyst, you found messages that were not included or were missing from the first phone image. Is that correct? Yes. How many messages did you find in the hard drive that was turned over? How many messages did you find that were missing from the first phone? A. I don't have that exact amount because what happened is because the images were captured at different dates, it doesn't match one to one. But roughly there were like a 6,000 message difference between the backup that we got in April or the image that we performed in April and the backup that we received in July. So there's a 6,000 message difference. Is that what you're saying? Yes. Could you turn to page 6 on Exhibit M at the very bottom in the conclusion section? Could you read the last bullet point there and explain to me what that 13,000 message number refers to? Yeah, so that's the comparison of one-to-one of the two databases that we captured, one in April and one in July. Okay, but I'm trying to understand the difference between the number you mentioned, which was 6,000, and this number here that shows 13,000. What's the difference? Well, I would need to check. I guess it's easier when you have both reports side to side. I only have this image open and I was going to memory, but the 13,000 messages was the analysis that my colleague performed comparing the two databases. So the 6,000 number, that number is not accurate? Correct. I was just trying to go by what I've seen before. Is there anything else that you testified to today that is just by memory or not by actually having the hard drive in front of you? No. All right. But the actual difference, so there were actually 13,000 missing messages that were recovered on the second hard drive. Is that correct? Can you specify what you mean by recovered? Well, you didn't have them initially in the first phone, right? You didn't have 13,000 additional messages. That's what I was trying to explain. It's not apples to apples, right? Because the time of the messages are different. So some of the messages can be just new messages that arrive after we perform the first image, and some of the new messages can be missing. Well, some of these messages can be just missing. Understood. And just so the court is clear on it, well, you got the phone April 9th, right? Yes. The backup, the hard drive backup was a backup of the phone, right? Correct? That's what I've been informed. Yes. And the phone was backed up onto that hard drive on February the 21st of 2025, right? Well, based on the evidence that I see on the backup, there are messages from July the 17th. Okay. The court. July the 17th of what year? 2025. Okay. By Mr. McGlemeth. All right. Are you able to tell how many messages are in the backup from April the 9th to the present date? I can. It would take me some time to filter the two reports. Okay, but you haven't determined how many messages in the relevant time periods. So how many messages from April 9th going backwards were actually recovered in the second hard drive? Correct. The information that the report about the 13,000 includes both situations, new messages and messages that happened after the image was performed. So the 6,000 number that you gave, that represents a particular time frame. No. It was just a round number based on what I've been quickly trying to answer your question. So the court, how much more time do you think you need? Mr. McGlemeth, maybe 2 minutes. I'm just wrapping up. The court, okay. By Mr. McGlemeth. So let me ask you this. In your analysis, do you determine whether other apps are deleted? No. So you only check to see if WhatsApp was deleted? Correct. You don't know if 10 other apps may have been deleted around the same time that WhatsApp was deleted? Well, first, I don't know when WhatsApp was deleted. Okay. And I see that it's missing from your original image, and I see that it's present on the recent backup, but only with 6 messages? Okay. We could compare the application between the two. We just haven't done that analysis. So you're not aware of whether Milagro Cooper deletes other applications when her phone memory gets low. You're not aware of that? No. Or whether that's a possibility? It's a possibility, yes, Mr. McLemon. But at least from, well, okay, that's it. No further questions. The court, all right, thank you. Mr. Sullivan, how much time will your redirect be? Mr. Sullivan, I think I can do it in 10 minutes, maybe 7 minutes, whether the court prefers. The court, I think our court reporter would need a break. So let's take a break for about 10 minutes and then we'll be back. Mr. Sullivan, I'm just going to come back. We have the new phone analyst in the old phone here, the court. So that will give me some time to do that and analyze that. So it's 11:35. Let's come back at 11:45, okay? Very good. Recess from 11:35 a.m. to 11:50 a.m. All right, y'all, we are on page 78, everybody. Page 78. The court. So, Mr. Sullivan, you're ready to do your redirect? Mr. Sullivan, yes, Your Honor. And I just have 2 points. I asked Matthias to bring up July, the later image, and see if we can put both of them together. And I talked to him, I guess, off the record, but I was in front of opposing counsel. Are we back on? May I proceed, Your Honor? The court, yes. Okay, so we're starting on redirect examination, everybody. Redirect examination. All right, Mr. Sullivan, Mr. Matthias, can you tell us basically what you've put up on the screen here? What are those 2 boxes? What are these 2 boxes? Yes. On the left side is a report that we were looking at the beginning that includes the gap analysis or the missing row IDs from the emails that were captioned in April. So this one here is you get the phone and you literally were able to extract with her, with Miss Cooper, the phone. Yes. And this is the analyst of the gaps there. Yes. What about this one? The one on the right is the space. Similar analysts looking for gaps. A number of missing row IDs on the emails that we received in July. The backup that we received in July. Okay. So these are the 2, the court. So I don't want to try to clarify. And Mr. McLemon has pointed out foundation. So the first set of documents we saw was received by FTI from whom and when. And then the second was received by FTI from whom and when. Let's clarify, Mr. Sullivan. And I think the lawyers were involved in a part of that by Mr. Sullivan. So am I right, Matthias, that this is the July delivery? Is that correct? Or is that right? Yes. I'm looking at the right-hand box. And on that one, FTI was giving a portable hard drive. That was a copy of a portable hard drive that Mrs. Cooper turned over to us. Is that your understanding? Yes, Mr. Sullivan. Now, on this first one, again, I think multiple people were involved, but I think it's common ground that Mrs. Cooper met in April in Houston with an FTI representative, Matthias's colleague. They did an extraction live with her and gave her back her phone. And then that was imported into the system the same way that the contents of the hard drive were. The court, thank you, Mr. Sullivan. Am I correct? Yes. So you have the 2 up here. And I think the question, that came up from Jeremy's questions is, did anything that disappeared in this December time period that we cared about showed up over here in the July, right? And I guess you can just go row by row and tell me, if you can, at least as to this time period, track the row ID gaps from the earlier extraction and see whether any of those changed or were restored in the July production. Right. So I know it's going to be a little bit small. Happy to try to change it in any way. But if you see here on the April image, yes, there were 3 missing row IDs starting on December the 2nd, 2022 at 1:22. And it's the same information that I see here, 3, on December the 2nd, 2022 at 1:22, the same time. The second line is also the same. And so I guess the big ones we've talked about earlier in the morning were the 66 and 276, right? Yes. I'm highlighting them on the screen. So 66 and 276. 66 and 276, December 22nd, 2022. December 22nd, 2022. So is it fair to read that the data that you've pulled up to say at least has the missing row IDs and corresponding messages that were not in the earlier produced phone? Those gaps that we're concerned about still remain in the data that was delivered in July? At the time period that we're looking at right now, yes. Okay, and let's just use the July. Can you go back to the October the 30th of 2024 period that we were looking at? I don't think we've done this, but let's do it on the July one. And I don't. So on the July one, just because I want to dispel any notion that there's on restoration. Yeah, so there are lined up on the screen now. Okay, so can any timestamp you draw a link here? October the 30th, 2024, 327. October the 30th, 2024, 327. Am I sure there may be one or two things off? Am I right to say that we're looking at the summary table for the July phone delivery and the deletions that we're concerned about on the earlier delivered phone backup are still present in this most recently delivered one? I cannot confirm all of them, but you can see at least the first four. They match exactly. Okay. And there was a question before, and I just want to clarify this for you, Judge. There was a lot of testimony. He asked you several times, he can't actually identify the date of the deletion, right? That's correct. And that's a fact of life in this forensic science. That's why this whole issue is so dangerous because you really can't, and it's done circumstantially, right? This whole gap analysis is a way to interpret the missing data. Yeah? Yes. By the contextual data. In this April 30th time period, Jeremy asked you several questions that said you can't, for example, there was a message on October the 31st. You can't tell whether there was deleted in the moment or it was created much later, right? That is correct. But what you're saying is, at least in this period after the preservation letter, what we do know is it existed and it was assigned to that moment in time a unique row ID. And that row ID couldn't have been eliminated until it was created. So by definition, if I'm starting with a date, say October 27th or some earlier date, I know that these October the 30th, 2024 deletions are after that, right? Correct. Based on the technology of the row IDs and the dates of the messages. Yes. Right. But it's nothing more than that, just numeral reality. I mean, the row ID wouldn't exist unless there was a text. And it had to have existed at the corresponding time in the sequence when it was its turn before it could get deleted. Exactly. After the date of the last message that is displayed on the database, Mr. Sullivan. Or is, in simplest terms, the date of deletion had to at least be after the date of creation. And if the date of creation was after a cutoff, it's the same. I think that's all I have on redirect, Your Honor. The court, okay. Mr. McLemeth, can I have one question? Just brief recross. The court, I will give you that. Okay, so we're on recross examination. We're on page 83, going to page 84. All right. Mr. McLemeth, you mentioned that the first four rows line up perfectly, but you see that at least in the fourth row, there were about 190 or so messages that were recovered from the second device. Yes. And there are numbers where they don't match perfectly, correct? Correct. This is just for this time period. This is for a stretch of maybe 48 hours or so, correct? Yes. This is not the full picture of all the messages that may have been recovered. Correct? Correct. This is just this point in time. Mr. McLemeth, no further questions. The court, okay, you may step down, sir. Thank you very much. Now, what I would need to understand next from the deposition of Mrs. Cooper is whether she received the notice, the preservation notice, and when she received it. And is there any dispute as to whether she received it or didn't understand it? Am I assuming that you asked all those questions during the deposition and that's what you want to present to me, right? Mr. Sullivan, yes, Your Honor. That's amongst the things, but yes, that's a primary thing. I don't think it's going to be disputed when she got it. She streamed about it on air. They got your video, girl. Why would you stream that online? See, you. All right, y'all. Okay, so there's no dispute as to when she got it. When was that she got it, Mr. Sullivan? It's a 30-second clip. It's October the 29th, the court of 2024, Mr. Sullivan. Yes, the court. Okay, Mr. Sullivan. And I think it may be in the first clip, the court. Does the defendant have any dispute with regard to the fact, Mr. McLemeth, that she received the preservation letter? The court, yes. Mr. McLemeth, that she received something related to the suit, but I don't know exactly what she received, Mr. Sullivan. Maybe it's worth playing the clip. I mean, I asked the question, did you understand you can't delete? And she acknowledged all of that. The court. Then we're going to need to play the clip, Mr. Sullivan. Okay, the court. And then I want to understand as to then, if she said during her deposition why she continued to delete messages even after the preservation letter so that I can understand her reasoning. I'm assuming you're going to play that clip as well, Mr. Sullivan. Yeah. I mean, and she didn't really give a reason. She said she didn't. Everything she said about deletions were going to play in one kind of package, the court, because I'm just trying to be as suspicious as I can to let you know what I'm concerned about. So once you know what I need to know, then that makes your life easier. You don't need to play an entire deposition for me, Mr. Sullivan. No, maybe just to anticipate where you're going. We've already cut it up. So I think it's going to be a total of maybe 20 minutes. So it's a chunk right on the deletions, and then it's really some things that go to intent, or she doesn't play by the rules. But the whole thing together is just 20 minutes. Okay, all right. So when I'll need to hear your argument and then defense argument after that. Now, with respect to defendant's expert witness, it's my understanding we talked about this issue at our last discovery hearing. And when was that last discovery hearing? It was prior to the deposition, Mr. Sullivan. July the 14th, right? The court, July the 14th. We talked about the fact that I would require plaintiffs to wait until after that deposition to file this motion for sanctions. And then that would be helpful in understanding the reasoning so that, you know, we wouldn't be arguing about this issue in a vacuum. And I think that at point in time, the defendant said that they would be getting an expert. So what I'm hearing now is you have an expert, and why isn't your expert available? Mr. McLemeth, why is he not available? The court, right. Mr. McLemeth, well, he's not available today in person, the court, but he could have appeared by Zoom. Did you ask for Mr. McLemeth? I think we did see an email to that effect, and I don't think we got a response as to whether he could appear via Zoom. The court, when did you send that email, Ms. Dixon? Yesterday, early, Mr. McLemeth. It was set on Monday. Everything was a quick turnaround. So after Monday, we got to contact the expert. We got to talk to him about his schedule. He's got to first respond to us. It takes time to get these things kind of hammered out, and we just didn't have enough time to do it, Ms. Dixon. And as soon as he communicated to me, I've called him several times, but when he did communicate, he said he was in Jacksonville and he would have no problem appearing via Zoom. But it's my understanding that no one could appear via Zoom. I forward that email to all counsel, including the court, that his response of, I have no problem appearing via Zoom. The court, that's interesting. I have not seen that email, but at any rate, does he have a report, Mr. McLemeth? Just the same as FTI has not done a complete analysis or some of the things I asked him questions about, our expert is even further back from that. And FTI is a bigger machine than just one expert. They've got people working around the clock on this issue. So he's not ready to do that yet. Remember, we just hired him, I think, that week of July the 14th or the week after. So he's not completely ready, the court. So let's hear her reasoning, because at any rate, there's no dispute that she has been erasing or deleting messages, right? There's no dispute as to that. What the court needs to determine is why. If there's negligence or if it's intentional. And what I have to do as a result, and what ruling I have to make as a result. And I'm not sure that the expert will be helpful to that either, Mr. Sullivan. I just want to add, Your Honor, we did talk probably around 10 days, around the time of the deposition, and they said, we have an expert. And I said, great, let's get that done. And what is your expert even investigating? The court, right, Mr. Sullivan. This is not really an expert. This is how the data appeared at one moment in time in another. Most of what he said is just math. So I don't even know what the option or the opinion he would get, Mr. McLemeth. So I can explain. So first, when he put his witness on, he talked about his expertise in Celebrate, in these Excel spreadsheets and whatnot. My expert would have given me more context for the things that were displayed here today. I don't know anything about missing logs or rows or anything like that. Whether they were the same thing as text messages, the SMS, the Wi-Fi from the WhatsApp, all the things that were deleted either immediately or at some other point in time. Those are the things I would have asked my expert. I found out about this stuff as I'm asking their witness. So the expert would have helped me to better prepare for this so that I could have the context and things that I probably still don't know, because I've only learned these things through their witness. So that is the purpose of me getting an expert, is to be able to challenge what they're saying. The things that they said or the testimonies they elected, hey, these messages were deleted right after we have the messages from the exhibit. That's what they had the witness testify to, but that wasn't accurate. So if I had my own expert to be able to let me know, hey, that's not accurate, that's not correct, then that expert would have been able to tell me, and if I wouldn't be able, have been just fishing and happen to find the actual truth about when the messages were deleted, and that he can't even say when messages were deleted. So what's the purpose of why I waited the court? So you're going to contest as to whether they were deleted before or after the preservation letter, Mr. McLemeth. So there are messages that they refer to in previous deficiency letters that are way before the lawsuit was filed, 2022. They referenced messages in 2024 before the lawsuit was filed. So at this hearing, that time frame of October the 30th to November the 6th that they honed in on just now at this hearing, I don't really think that was in the previous deficiency letter. There were other dates years before the suit was even filed, and they were trying to say that Miss Cooper was on the notice and that she was going to be sued because they said online, sue me. The court, okay, Mr. Sullivan. So, Your Honor, the court, no, I'm sorry, I'm listening to Mr. McLemeth. Mr. McLemeth. So I was preparing not just for this October the 30th to November the 6th time frame, but also messages from way before then. And the dispute would have been that those messages could have been deleted well before she got any notice. The court, okay, those messages. But if we're talking about post, messages received or conversation after the preservation letter, we'll just focus on those then. All right, thank you, Mr. McLemeth. If that's all we're discussing now, then I'll focus on those and we'll go from there. The court, thank you very much. Mr. Sullivan. Just the last thing on the prejudice, Judge. I mean, all of us are trying to reconstruct forensically. Miss Cooper knows it all. She knows the reasons for those deletions. She can tell him factually if there's some set of life circumstances that could create those gaps. I mean, they have the market cornered on that. You'll see what she said in the depot, but there's nothing informative. The court, okay, so let's match what you have so that hopefully we can be done by 12:30 because I do have to move on to the next matter. Mr. Sullivan, yes, just play it right though. Video play from 12:08 p.m. to 12:21 p.m. The court, can we hold it a second, Mr. McLemmons? I think we're veering off on the points. Mr. Sullivan, it's the last one. The court, okay, you withdraw your objection? Mr. McLemmon, yes, Judge. The court, okay, go ahead. Video played from 12:22 p.m. to 12:23 p.m. The court, okay, so I'm not sure about the relevance of that as to whether she erased messages from her phone. Mr. Sullivan, well, I think this is the last one, Judge. A few of these, frankly, are meant to show that this particular witness, again, we're looking for a finding that she intentionally tried to deprive us of evidence. There's a lot of evasion, of not playing by the rules, of doing things in a way that is manipulative. And I think that this clip about her saying, I can get away with this because I didn't post it myself. I said, go to my likes and find it there. I mean, intent is something to say about somebody. The court, okay, Mr. Sullivan, that they would delete messages to help her case. Well, their case. And I think some of this suggests that you have to decide whether she's that kind of a person, but she seems to take a lot of liberties with the rules of these other engagements. The court, all right, I see your point. So I have the transcripts here in the paperwork that you sent me. I'm assuming this transcript will have that information. I know I've highlighted some of the information that I hear there. So I don't know that I need to see more unless there's something specifically going to her deleting messages. I think I've seen that now live from the video, and I've read that in the transcript. She's acknowledging receiving the letter. Mr. Sullivan, one other. If I could just show you one of the exhibits that didn't really show up while she was talking. It is one document. It would take just 30 seconds. For the record, I've marked for ID Exhibit F. It is a copy of a tweet in the exhibit where we were discussing. Ooh, excuse me, y'all. Had a burp. Sorry about that. It is a copy of the tweet in the exhibit that we were discussing with the witness on the clip. And I'll just tell you, if you look on the back, Judge, the relevance of this, she's saying that she's saying about her right to do what she thinks she's doing. And then she says, what would the lawsuit be for that? And this is back in June, right? June of 2024, right? So I would put that, I mean, that was very provocative. And she was saying, I think I can do this and get away with it. And why am I going to get sued for that? I think that shows somebody who is aware that they're at least playing with the line in litigation could be coming. And just in terms of the date, you should start thinking about when she should have been preserving things. I think we have a couple of points in the timeline where she's looking at litigation. So it's just for that. The court, thank you, counsel. Mr. McLemmon. I guess just on this last exhibit that was entered again, I don't know if we're arguing for all of the periods before they actually sent this notice letter, but this seems to, I guess, put an argument forth that they want the court to consider dates before that. I'm not sure whether we're arguing where the goalposts are. So if I could get an understanding of that, I could know where I'm arguing and where I'm going. But even this, when she says, what would the lawsuit for that be? I mean, she's literally saying that they don't have any lawsuit against her. That's her understanding of it. The court, right. And I agree with Mixed McLimith on that. It seems to be that maybe she doesn't understand her legal rights or what she's legally required to do if she seems to think there's no lawsuit for that. But from the date in which she receives the preservation letter and acknowledges that she has the preservation letter, I don't see how I can ignore that she's deleted after that, Mr. McLimit. And I'm not telling you to ignore that, Judge, but if we're honing in on that, then it's not just about whether she deleted messages. There's some other considerations that the court has to make before it takes a determination that Mrs. Cooper is liable for sanctions in this case. The court understood, Mr. Sullivan. And just to preserve our position, Judge, I agree with you that the focus, it's an easier to understand focus on these post-preservation letter. But I think our position is going to be, and I think the law supports it, that reasonably anticipating litigation in this context is broad enough. I think to embrace someone who's saying, sue me, which is what the earlier text said, and there's more if we're going down that path. So we do stand by that. But I understand that your honor's prioritizing this, the court. I understand your argument, but if this is the evidence you have that she was aware that she could be sued, this isn't sufficient. What else do you have? And even if you have that, I guess my concern is, as a non-lawyer, how is she to have understood the importance of preservation of evidence? And so I would need more, Mr. Sullivan. I'm going to give you the other exhibit we have that explicitly mentions, I will say, Judge, you have the whole transcript. And Miss Cooper took classes in criminology. She went to the Tory Lanez trial. She covered that. She took detailed notes. And I think as a person, and you'll hear from the transcript, that has a great awareness of litigation and what was going on here. And our lawyer allegation is that she became part of that team and was deployed to do things that couldn't do themselves because he had a gag order. He wasn't going to say anything specific, and she became the messenger. She was in a legal machine. She was in a legal machine. And the exhibit E for ID as Bates number 2554. And let's see, this is February the 23rd of 2022. It's after the verdict. By the way, Judge, we spent all that time on the December 22, 23. That is when the jury was out in the Tory Lanez shooting Meghan case. The courts. I see, Mr. Sullivan. And that long gap is literally during that case. We're happy to submit law on that. I think it's your call on when she would have been aware. But I think compared to most people, if you read her transcripts, she had a very good sense of what this is and what she was doing. And she was certainly in the system. When she sat in that case, the gag order was there. I mean, it was a big fact of life for people trying to talk about this, and that some people were gagged. So we stand by the argument. You'll be the judge, the court, all right, Mr. McLimith. And just to briefly respond to that Miss Cooper went to college. She did criminology. I majored in criminology. I practiced primarily criminal defense. At no point in time during my practice or in college was I taught that I should preserve evidence for a criminal matter. The two things don't go together. So that's not proof that she, as a layperson, would have any idea that she could or she should preserve evidence because she made a comment about someone on Instagram or Twitter or whatever. The court. All right. Thank you very much. What other evidence does the plaintiff have, Mr. Sullivan? That completes our evidence, what we put in the court. All right. Thank you. And what evidence does the defendant have, Mr. McLimith? Again, Judge, if Miss Cooper were here, she could probably answer the question more, I guess, definitively as to what was deleted and her reasoning why. In one of the clips that we just saw, Miss Cooper was starting to explain that time period for the screenshot. So you could hear in the video counsel, well, you could hear in the video counsel was asking about the November the 14th date and what was going on around that time. Miss Cooper began to say, and I wrote it down, November is when I do a trip every year. And the video cut off. And I don't know where in the transcript that is at, but she was able to explain something in the video, just cuts off. So, I mean, I could ask that portion be played because that was really the only relevant portion of that entire video that was answering the question that the court was asking. So I can tell you this, proffer, right, of what we've been told by our client, that she deletes messages and apps on her phone at different periods of time because she creates content and her phone gets full. So if she is on a trip, which I think she was about to say that in the video, and she needs space on her phone for videos or photos or whatever, she'll go in and just delete random threads or group chats that she has to make space. And then she also deleted things that she didn't think were relevant to this case, right? And that doesn't call for spoliation sanction, but if she were here, she couldn't come because of this flight issue. We spoke at the airport last night. She said she was about to board in 15 minutes and the flight gets canceled. So she's not here to testify to those things. The court, I understand. So I have that page of transcripts, and basically it just says, November is when I do a trip every year. And she says, I have to edit a lot because I do like a mock reality show. Okay. Do you think that these deletions are related to the mock reality show? These messages? Yeah. Oh, her answer was like, why I may have needed space. And when she asked if she was creating space for her show, she answered yes. I wouldn't say that for certain. You just asked me what kind of going on around that time. I don't know why. So I do have the rest of that answer. I do have her testimony with regard to the deletions. I don't see where I needed more. I also need to hear from plaintiff then on what sanctions are you asking the court for, Mr. Sullivan. I think that we have a proposed order that started this initial process, but it's a finding of intention to deprive us of this evidence. Certainly, post-preservation letter instances of deletions, adverse inference, and then in what we submitted in the proposed order, there are some detailed findings that would affect, and I can hand that up if you want. But it's going to be an adverse inference. Again, I have a lot of these cases. This really needs to have teeth. Nowadays, if you delete it, it's going to be gone. This problem I have that I can't say when they deleted it, it's because the bad guys are as smart as the good guys. And this is just the way to do it. And anybody can go on YouTube and learn it. So this has to be not worth doing. So a serious adverse inference, and we have the language in the proposed order. The court, all right, thank you very much. So I think I have everything I needed to make a decision in this case. Quite frankly, in terms of your expert, I don't see how your expert can give me any more information with regard to the deletions. I am looking at the emails here that my law clerk has printed out for me, and none of them does it say that you are requesting your expert to appear via Zoom. So perhaps there is some misunderstanding and that email just never was sent. I'm good to go ahead and prepare an order in this case. And the next question I have is with respect to timing. And I know that there is a deadline, I believe, tomorrow for dispositive motions. I don't think I'll have the order out by tomorrow. So just letting you know, this is not something that can happen overnight. Mr. Sullivan, understood. I think we're going to live with whatever that is, and we'll make adjustments accordingly. And I do think our urgency, though, Judge, that evidence on those rolls is gone. We have to plan our case without it and know what we're going to have instead, right? Is it nothing? Well, it is nothing. The court. And of course, you can argue in your dispositive motion that the evidence is gone, Mr. Sullivan. Yes. But I think at this time, we are probably not going to make a summary judgment motion in this case. Just go to trial. The court. All right, Mr. McLemeth. And Judge, I did want to put some case law on the record for this issue, if I may. The court, go ahead. Ooh, excuse me, Mr. McLemeth. Okay, sorry. So I'm looking at an order from a case in this district. In the order cites case law. It says a movement must show that the spoliated evidence is crucial to the movement being able to prove its prima facie case. I think there's a gap there. It says prima and then facie. All right, let's continue. It is not enough that the spoliated evidence would have been relevant to a claim or defense. So relevance is not enough. And then it cites to another case and gives a parenthetical finding that's although relevant, spoliated evidence is not crucial. Another parent, I don't know how you say that, where I'm butchering the heck out of it. After that, allegedly, spoliated evidence is not crucial to plaintiff's claims because it could prove its case through evidence obtained elsewhere. Generally, only outcome determinative evidence constitutes crucial evidence. And in this case, the text messages that are deleted, we don't know who sent the text message or where they were sent from. We don't know. And they were deleted. We don't know what the context of the text messages was or is. We don't know pretty much anything about the text messages to even make the argument that they are relevant to this case, much less crucial to the case. Opposing counsel started by mentioning that there was some case that was that he was a part of, and that there was, I guess, one message or one email that identifies something, some meeting or some negotiation between the parties. And in that case, obviously, it's distinguishable from this case because the central issue in that case, or I guess whatever the judge was considering, I don't know because he didn't actually cite a case. But the issue was whether there was some negotiation or whether there was some proof of a negotiation. And there was proof of negotiation, I guess, in the form of some email that was deleted. In this case, the messages that were deleted in order for them to be relevant, they would have to be messages or have some indication that these messages had something to do with the claims in this case. And then once we get that threshold understanding down, those messages have to have been crucial for them to prove their case. And in this situation, they haven't established any prejudice because if those messages were about her going swimming or going to the beach or taking her kids to school, then there is no spoliation. There's no prejudice in them having those messages. The messages that she was asked to preserve are messages. I would assume are messages that has something to do with this case, not messages that has nothing to do with this case. And if she deleted messages that have nothing to do with this case, then those messages should not be considered in the court's determination as to whether there's a spoliation sanction to be given. The court. Okay, I certainly understand that the messages would need to be crucial. The problem that I see, and I can tell you preliminarily, is that without the messages, there's no way to know whether they were outcome determinative. So she needs to have put herself in a box in that situation. Mr. McLemeth. Well, I guess in that situation, then every case in which there are deleted messages, because we don't know the exact nature of those messages, then in every case where there's a deleted message, even just one, there would be a spoliation. Somehow it would be subject to spoliation. It would be a per se ruling. And I don't think that's the case. The court, correct. All we can look at are the circumstances surrounding it. Mr. McLemeth, yes. The court. And I appreciate that. All right. Anything else from the parties? I think that's all we've heard from everyone. Everything that is to be heard at this point, and I appreciate the arguments and the evidence. Mr. Sullivan, can I add sort of just one footnote at the end? We had 2 or 3 other tiny items. We don't have to go into them, but you mentioned the summary judgment. So there's a fact discovery cutoff. There's a couple of small things we've talked about that based on this ruling we'll have to adjust. But I think we can probably work it out. But I just want to put a placeholder that we might have to come back to you whenever we see you again on this cleanup stuff. The court, okay. I think with respect to Judge Octanaka's discovery deadlines, if the parties agree that there's other discovery that needs to be done, then Mr. Sullivan, I think we can work it out. The court, there shouldn't be a problem, Mr. McLemid. So if we're doing more discovery, what about the dispositive motion deadline that is tomorrow? The court, I understand. Are you filing a dispositive motion tomorrow? I mean, maybe in a claim or two, possibly. The court, well, that's entirely up to you. But with respect to further discovery, I don't know at this point what you're talking about, Mr. Sullivan. I think on our side, and we've talked more with Ms. Dixon about it, but we have, I don't know, a handful of documents, subpoenas that are basically to the other side of some of the missing transactions or communications to try to get in that way. The court, through iCloud, you mean, Mr. Sullivan? Pardon? The court, missing communications. Are you trying to get them directly from iCloud or Mr. Sullivan, or from AT&T, Instagram, whatever? Okay, so let's pause here. As y'all see here, it seems that Megan's team is going to be sending out subpoenas to iCloud and AT&T. Okay, let's continue. Is there any objections to that, Mr. McLemid? No. The court deputy, Your Honor, are exhibits F and E admitted? The court. So the last exhibits we have are E and F. Any objections from defendants? I think your objection was relevance, Mr. McLemid, earlier. Oh, well, yes, but I mean, this is the same objection as before, lack of foundation. So I'd make that objection. And I'd renew my objection on exhibit AA, which the witness could not lay any foundation from earlier, Mr. Sullivan. On the first one, I believe the witness authenticated the exhibit in her depot and have the transcript. And you have the transcript, sorry. And again, on AA, I think we're not putting it in for the truth. We're putting it in for an accurate depiction of, I think probably as Jeremy exposed two different parts of the analyst, Mr. McLemid. But I'm not making a hearsay objection. I'm making a foundation before we get to whether it's hearsay. You have to lay foundation for the exhibit. So that's what I'm arguing, not hearsay, the court. So his concern is, where did these come from? Mr. Sullivan. Oh, are you on the tweets? The court. What is a tweet? F? Mr. Sullivan. Are you still objecting to that? The court. And E is also some tweets, Mr. McLemid. I think his reputation, and I can't remember if Milagro Cooper stated in the deposition transcript that those were her tweets, and I take that for what it is. AA is my issue. The court. Okay, Mr. Sullivan. And again, on AA, I think the foundation was on the record with an expert. The foundation is whether the source information is exclusively her phones. The court. I think we went over that a couple of times by asking questions about where the particular extractions came from. I don't know how to clarify that more. I think, Mr. Sullivan, it's no better or worse than what he said. We have it all here, and there's different ways to extract it. Anyway, my response to the objection is I'm not offering it for more than what he said it was, Mr. McLemid. And what he said was he doesn't know if the screenshot with the metadata comes from the first phone or the second hard drive. He also said he had never seen this exhibit before today. And he said that he didn't know what the last modified date necessarily was. He didn't know if it came from Milagro doing something or something else. He doesn't know anything about this exhibit. The court. Let me double check, because I thought that he said it came from the second extraction. Mr. McLemid. He said it came from the first. The court. Oh, so he did try. Well, he did say it came from the first. So that is where it came from. That's the source, Mr. Sullivan. I thought the confusion that you brought out, Jeremy, was that on the right-hand side, there's some relatively metadata. And he was confused about where that came from. And is that the right answer? And then the part on the left side, he said, did come from her original phone, Mr. McLemith. Well, yeah. So Exhibit J comes from the first phone dump, or actually, I think Exhibit J was produced in discovery. Actually, but this exhibit itself, I'm not splitting the exhibits from left to right. The exhibit itself had never been seen before, Mr. Sullivan. And again, Your Honor, reprinted it out literally to try to answer a question that you raised, Jeremy. The court, oh, AA included a last modified date, and he had not seen it before. I understand, but the actual screenshot itself, he testified that he had seen that and that it came from the first extraction, Mr. McLemith. Correct, but there's no metadata on that first exhibit, Exhibit J. The metadata is what I have an issue with, Exhibit AA. The court, okay, in the metadata that was something counsel produced, I want more information then, Mr. Sullivan. FTI pulled the metadata from the phone that was associated with that image. The court, right, but not your witness, Mr. Sullivan. That's a good, it sounds to me not him personally, but somebody else looked at it and it put it together. The court, so your witness cannot authenticate that document that's coming from the FTI, Mr. Sullivan. Oh, I think he did. No, it's literally a product of the same database he was looking at up there with his computer. The court, okay, Mr. Sullivan. I think whoever generated it when that question was asked is not him, but I think his answer addressed again, he can't defy an exhibit, but he addressed what he knows about for the exhibit. So he knew about the screenshot and he understood that this was relatively metadata. I'm sorry, I'm said relatively, relatively, sorry, y'all. Process metadata that originated with the phone. The court, can he put him back on the phone? Is this here? Did he leave? Mr. Sullivan, sure. The court, there he is. Let's get some more clarity about AA. The witness, do I need the laptop again? The court, no, just give him AA. The court deputy, I have a copy. I just need it back. Mr. Sullivan, Your Honor, while he's doing that, we have prepared a short proposed order on our adverse inference. And it has language in there. If it's okay that we hand that up, the court, yes, of course. And make sure a copy for opposing counsel. The court deputy, sir, you were reminded that you're still under oath. The witness, yes. So right now, we're on page 110. This is a redirect examination, okay? We're almost at the end, By Mr. Sullivan, Matthias, do you have AA in front of you? The exhibit? Yes. And you heard all the questions everyone in the court was asking. Basically, tell me what you understand about the source of the data there and the actual presentation of it that you're looking at. Yes. So on the left side of the exhibit, there's the screenshot that I have seen on the original image. The right side of the exhibit, I recognize that it's the metadata view from Relativity. I'm getting tongue tied. I'm getting tired, y'all. But I haven't personally looked into those dates and tried to make or understand that they meant what they meant. Okay, then you were asked a specific question about what the modified on July the 17th of 25 could mean. I mean, you speculated that you didn't really have any personal knowledge of that, right? Correct. I don't know. So is it more fair to say that you recognize the screenshot, but the relatively data to the right, you're not personally able to attest to because you hadn't dealt with it before? Correct. I didn't access the reality database for this case. Court. And how would that data be accessed, sir? The witness. It's a platform that's used for document review. The court. Is it something that FTI would have? The witness. Yes. The court. Okay. And would you be able to determine if you looked at this data, the origins of that July date, would you be able to determine that, or are you testifying that it cannot be determined this modification? The witness, I can't confirm it all. I can spend some time with the image and try to determine whether this date or where this date is coming from. This is the court. My question is it impossible to determine, or can it be determined? The witness. No. It can be determined based on the other evidence that I have around this file. I have to see what the source is, what is stored on the phone. There's a few things that I need to check to explain better if the last modified date is related to something that happened on the phone, or maybe something that happened when the picture was extracted from the phone by Mr. O'Sullivan. But either way, this is explaining a July 25th date. And you do have access to the database that will tell you that, right? Yes. And you assessed it before the database? Yes. In reality, the reality database for this case, I haven't. Now, there's something that matches. When I saw this, the image on the phone, I found it based on data filter, and the date was 11/14/2024 on the source device. The date that I used to filter and find this exhibit is the created date. The court, I understand, Mr. Sullivan. I understand. Okay, bye, Mr. Sullivan. So you're able to place that in time based on that, and it's not related to the July 2025 modification? Correct, Mr. Sullivan. Do you understand that, Judge? The court, yes. But I understand that he's also saying that he cannot confirm at this point who modified the document on July 25th, 2025. Mr. Sullivan, right. Or what it was. I just want the record to be clear that the database itself doesn't show, or does show, could show right now that the metadata tells you it's that November 14th of 2024 date. That image, right? That's in there. The court understood. The witness, yes, the court. So to the extent that that's been confirmed by the witness, I would accept the evidence in the exhibit. Oh, we're on page 113. We're almost there. As far as the... Okay, so let me continue. As far as the July 25th date, that has not been verified by the witness. So that date will be disregarded. Thank you. All right. Thank you very much, counsel, Mr. McLemith. So one last thing. I did not put the actual case on the record. I just want to do that. The court. Oh, the case law regarding the outcome determinative issue, Mr. McLemith. Yes, Judge. So it's in this district. The case number is 20/CV/2987. It's docket entry 46 from August the 3rd of 2021, Judge Jonathan Goodman. The court, thank you. Thank you very much, Ms. Dixon. And Your Honor, regarding the email, it was sent on August the 6th of 2025 at 2:11 p.m. It was copied to all parties, including the court. And what I did was I forwarded the message from Thomas Pullen, who was our expert, and he said, Rhonda, I can be available via Zoom, but at the moment I'm in Jacksonville. Can you get it to be Zoom? I've done a lot of hearings via Zoom. They should be okay if you ask. And I forwarded this to the court. Maybe it was unclear, but I was told that nothing could be done via Zoom, and the client could be appeared via Zoom if that was a possibility. But all flights for United were canceled. And that's a matter of public record. And she was actually in the airport when that happened. So she wasn't able to get here today. The court. All right. Thank you very much for that information, Mr. Sullivan. One tiny last housekeeping. Judge, can I just make sure that E and F were admitted? If not, I would ask for those to be admitted. I think they were. The court, yes, all the other exhibits were admitted, Mr. Sullivan. Any objection to E and F if they are not already? Mr. McLemith, no objection. The court, all right, thank you very much. So, Mr. Sullivan, thank you, Your Honor. Ms. Dixon, thank you, Your Honor. Proceedings concluded at 12:53 p.m. Certification, and this is just the site. So, Oh, we made it, y'all. We made it. This is just the index at the bottom. So a few key things that I see. There was some issues with some of the exhibits. Milagro Elizabeth Cooper couldn't get a flight. The flight got canceled. They did bring up her deposition. They did bring up the deletion of text messages. And as of right now, it looks like Megan's legal team will not file anything pertaining to them trying to get certain things thrown out. But I know Milagro they submitted it, but it's the matter of if it's going to get approved or not. We'll just have to wait and see on that on the docket. And I appreciate all, I don't know if that's how many in here right now, 6,786. I appreciate y'all for being in here right now with me. We've been in here almost 3 hours, and I know I got tongue tied on a few things, but I appreciate y'all for being with me. This was a good stream, long stream, but I appreciate everybody who was here. As I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, until next time there's another court update, then we will be back and we will be reporting. Okay. I hope y'all have a great night. This Saturday night, go out and get you a nice little drink. Yay, but you know what I'm saying? Go party, do whatever you got to do. Y'all have a good one though. Bye-bye.